Uh, you guys hear me? Uh, so Dakota, if you're on, Dakota, you on, brother? All right, I'm waiting for Dakota to get on. He's with Mind Evolution. He's gonna act the moderator here because I had a really difficult time yesterday being able to filter through comments and everything else. So I want to give you guys the opportunity to be able to ask questions, give you guys the response that you need. Can you guys hear me all right? If you can, someone just give me a thumbs up if you can. I just want to make sure. Yeah, I got a heart. That wasn't a thumbs up, but we'll accept that. I think you guys can hear me. So just that you know, I'm in a grocery store here, and so there could be some noise in the background. As you can see, there's some flowers up above me here. Uh, so um, if there's some background noise, you guys forgive me. We work with what we got within the parameters that we have. Awesome, got a thumbs up. Hey, Dakota, if you're on, brother, you need to give me an invite. You need to send an invite to share the screen with me, brother. You need to send that invite. Um, if he doesn't come on, we'll bring someone else on. Maybe as you guys ask some questions, maybe we can bring you guys on. I have the multi-screen. Guys, I'm not really familiar with this particular app, the TikTok. This is only the second time we've done it here, but let's let's do the best that we can here. So I want to give you guys an opportunity to ask whatever questions you can. Guys, bear in mind that what I give you is the best information I can give you. Right? It's up to you guys to make the best decision in your particular situation. All that I can do is just give you my understanding of the law and the best advice that I could give. I'm an advocate. I speak on behalf of others in a legal matter. I'm not an attorney. I would never claim to be an attorney. Attorneys go through administrative law. I'm not an administrative officer of the court. I am an individual that's able to investigate, prosecute, and bring forward criminal elements, which is why all of the stuff that I focus on is criminal related, as opposed to typical lawsuits and everything else. You guys, y'all want a lawsuit? Y'all want to sue? I don't care about money. Money doesn't matter to me. What I care about is what's right and what's wrong, and that means that criminals are held criminally liable for the crimes they commit against people in the United States. So, if you guys want to throw out some questions, let's get some questions out there. Please try your best to keep these questions as general as possible, not so much specific to your own personal situation, but if we can keep them a little bit more general, that would be awesome. That way we can help as many people as possible. So, um, okay, so what we need is the people in power interpreting the law not just any way that they want. You're absolutely right. You're right. So, the law traditionally has been used as a weapon of oppression against those that are disenfranchised. That's it's well known, especially case law, especially rulings. So, we live in a society that's known as a government of laws. That's what we all believe in. You all believe in it. I believe in it. We believe in a government of laws. That means that the laws are the foundation, and everything must derive from them, right? So this is actually part of my oral arguments, but it kind of explains it a little bit. Um, the great philosopher Nietzsche once said that those who fight monsters should see to it in the process they don't become a monster. There are two vastly opposing legal doctrines at work in America at this time. Our system of government is founded upon the government of laws doctrine, which is constitutionally based. It's built upon the theory that in order for laws to be legitimate, they must be considered just and equal. This is the egalitarianism approach, which our Constitution is framed upon. However, in order for all men to be equal, government laws must first treat them equal. This is the way that our system is designed to work, based upon a fixed set of laws or principles in which the courts and people adhere to, and to which every United States citizen is accustomed to. Now, the opposite of the government of laws doctrine is legal realism, which is very much alive and at work here in America, destroying our system of government and infringing on the rights of the people. Legal realism, of course, is the theory that law is not based upon a formal set of rules or principles, but instead upon judicial decisions deriving from their own social, political, or public policy. This is not constitutionally based, as it does not permit the fair and equal treatment of people. So, as we talked about yesterday, right? There's two main issues here, right? Or two main legal doctrines that exist. We all believe in the government of laws doctrine, which places the Constitution at the foundation. Everything derives from it. That is a government of laws doctrine. The opposite of government of laws doctrine is legal realism, which is the belief that judges make the law, right? And that law is based upon their own social, political, or public policy. But that is not constitutionally based. That is judge-made ruling based. Okay? So this whole concept of stare decisis, for instance, is completely erroneous. It doesn't even make sense, because stare decisis means that judges are able to alter, amend, or destroy the constitutional laws based upon their own social public policy, whatever they want, because there's millions of cases that they can choose from. You all know that we can go out to the Constitution. We can say, okay, the Constitution says that we're entitled to an indictment by a grand jury. We can go out to In Re Looney and see that, oh, the Supreme Court said that we're entitled to a grand jury. We can go out to In Re Anderson. We can see that an indictment by a grand jury is required. But then we can go to Hurtado versus California, where they say, no, it's not. So if the judge wants you to have an indictment, then they can say, oh, well, this case law says that you do. But if they don't, then they can say, oh, this case law says you don't. They can always find whatever they want based upon their own desire. That's why every case is a predetermined outcome. You know, they already know the direction that they're going to go. And I had this discussion earlier with some people earlier that, you know, one of the big issues that we have, and one of the things that we need to remember, is this concept of as above, so below, right? As above, so below. So what we have going on in our own individual lives, individually, we can see the same thing manifesting collectively, right? We can see it. So a good example, would be the southern border and the whole border protection issue. You know, when Texas stepped up and they said, okay, we have the right to defend our border because you, government, are not defending it for us. That means that the government, the federal government, the border protection is not following the Constitution. So the real issue there was, does Texas have the right to stand up and enforce the Constitution of the United States when the federal government fails to fulfill their obligations? And the answer is absolutely they do. Texas absolutely does. And not only do they have the right to, but they actually have the obligation to, because they have to enforce the Constitution of the United States. Now, you know, that would be above, but below is the exact same issue I have. Do I not have the right to stand up against the state of Washington when the state of Washington says we don't have to follow the Constitution of the United States? I absolutely do. I have a right. Not only that, but I have a duty to do it. So as above, so below, we're going to see in our individual lives the same thing that's going on individually to collectively. And so another example would be the whole and I'm not political. I'm not saying anything political here, but I'm saying that there's a lot of evidence that shows that there was election fraud that existed in the last election cycle. We see that there's evidence that's available, but as above, so below. You know, individually, every single day there's an election that occurs individually. It's called a jury. And so if the individual doesn't have the right to a fair election process because the government has made a predetermined outcome as to who is going to win and who they selected to win, then wouldn't you expect to see the same thing collectively that's going on individually? You would. So every single day, there are elections that are being deprived of people every single day because the government has taken a side and chosen to obstruct the fair election process individually. So we can see collectively the same thing happening, and that's why, you know, a lot of times, you know, I can kind of predict the future. I can kind of see what's going on outside because I take very specific notice of what's going on with me individually. So one more great example is that if we walk into a courtroom every single day and the prosecutor, who's part of the executive branch, is in direct collusion with the judge who's part of the judicial branch, then we can expect that we will find the same thing collectively where the president of the United States is in direct collusion with the Supreme Court of the United States, because that's what's happening individually. We can expect to see the same thing happening collectively. So, that's why, um, you know, I talked about it earlier too, with some people that when we had the Chevron ruling, right? The Chevron ruling was all about the Supreme Court coming out and saying, "Hey, executive branch, you don't have the authority to alter, amend, or destroy the law. You don't have the authority. That's a separation of powers issue." But nobody questioned the very next week why the Supreme Court made the ruling that Trump is immune, right? And I'm not saying that's wrong, but what I am saying is that those are two diametrically opposing rulings. So those two, they don't even make sense. One case, one week they say, "Oh, executive branch, you can't do whatever you want," and the very next week they say, "Executive branch, you can do whatever you want." You see, these rulings didn't make sense, and you have to understand that there's an underlying deceptive nature in those rulings, and you have to get to it. There's a quid pro quo that exists, and I'm not going to go into what that is, but when you have two completely opposing rulings and then nobody questions it, there's a problem there. So yeah, let's see if we can find a question here. Okay, thank you for coming, California. Yeah, or Oklahoma. Yeah, we started this in Tulsa, Oklahoma. Um, it was almost a year ago, actually, to the day that I first went to Oklahoma, and I love Oklahoma. I mean, I've made so many friends there. I love the people that I have there. So, hey, Dakota, you need to ask to join as a speaker or something. It needs to come from you. I can't request. You need to request it to me, and then I'll add you in. Okay, brother. I'll go in just one second. Let me finish this Oklahoma comment. But yeah, I love you guys in Oklahoma. I love the area, and I can't wait to get back and see you guys. You guys have been amazing. You've been so supportive of everything we're doing. You guys are oppressed and have got all kinds of problems there. And I really hope that Governor Stitt steps up here, because we've had a conversation with Drummond and Stitt a couple of different times on these issues, and I thought that they understood. In fact, I've talked many times with Governor Stitt's father, who is a retired pastor, and he's a little bit concerned about Stitt's spiritual future, and I would be too if I were Mr. Stitt, because we brought it to his attention that these things are unlawful and unconstitutional. And I know that he was made very, very aware of the situation. And yet he's chosen to just continue to act in an unlawful manner, which means that he's now knowingly and willingly engaging in criminal behavior. But when I first got to Oklahoma, I'll tell you, I knew nothing about Black Wall Street, nothing at all. I'd never even heard of it. And I think that that's kind of society's issues here, is that we're told the history by the people that are in control, right? And they don't really want to have some things known. But when we talk about September 11th and the attack on the towers, and we say that was the first time that there's ever been an attack on American soil, that's not true, everybody. That's not true. We ourselves, like we attacked our own people in Tulsa, Oklahoma, and we did some horrible things and killed a lot of people. And I went into the AME church and went down into the basement of it with the pastor, and we could see, this was like the only building that was left standing after the bombing in Tulsa, Oklahoma, from Black Wall Street. And you guys, if you don't know the history of it, go out and read about it where you can. There was we bombed our own people there because the blacks were getting wealthy, and for some reason our government decided that they didn't like that, and they wanted to shut it down, and they went in and supported the bombing of our own people there. And it's a pretty disturbing story. But I went into the basement of the AME church, and I actually stood and put my hands on the poles and the posts that are down in the basement there, and I could see where the accelerants actually would drip down the poles. It's still there, like and this is the place where 400 people stayed in, didn't know that they were going to survive or not. And there were 400 people down in this basement that It was the only building that survived the bombing. Anyway, yeah, we started in Tulsa because I felt pretty strongly that was a good place to start. God said let's do it, and so that's why we did it. We need to understand our history a little bit better. We need to come to know the truth of history as opposed to what we're being told about history. And so, yeah, it's an honor to be able to go and do that. Um, so I'm gonna add Dakota in real quick here, guys. Just 1 second. All right, Dakota. So I can't. It says that I have to be live 3 times before I can add anybody on, which is just the weirdest thing because I just went into practice and it said that I can do it. So, brother, I guess we're SOL again, man. What's going on? All right, so let me find a question here, guys. Let me scroll up here. Thank you guys for joining us here, and so Oklahoma is not the highest per capita incarceration rate. Actually, the state of Florida is. There's 140,000 prisoners in the state of Florida. They imprison at a much higher rate than any other state. 140,000 prisoners is insane. But also not just statistically, but the state of Florida, they actually have more people serving life without parole than 15 other states combined plus 1,000. I mean, and that should be repeated. 15 other states combined plus 1,000 serving life without parole. These are people that have no opportunity ever to be able to get back out. And one of the egregious things about the state of Florida, in the life without parole issue is that the state of Florida's own constitution states you cannot give someone life without parole. That was a concession that was made in the establishment of the Constitution after the Reconstruction Amendments of the 13th, 14th, 15th Amendments. After the Civil War, the Reconstruction Amendments, one of the concessions that was made was that you cannot give someone life without parole. It was written into the Florida state constitution, and yet every single day, judges all across the state of Florida give life without parole. They hand it out all the time. And so, the guys down in Florida, Society First is a great example. Society First is in the front with trying to resolve this life without parole issue that's there. They've had a very difficult time getting their case into the federal court, and the reason why is because the Florida state constitution says, yeah, you can't give life without parole, but the United States Constitution doesn't say it. And so what happens is that when they try to bring their case to the state Supreme Court just ignores it. We're not going to hear that case. We're not going to make a decision, because they claim to have discretion, right? They claim that they have the discretionary authority to be able to determine what case they want to hear or not hear. So they don't hear it. They just refuse to hear it. And by refusing to hear it, they never have to make a decision. So you never actually get relief or remedy, going through the state court. And so then when they try to elevate it into the federal court says, oh, that's a state issue. Go back and argue with the state. And then these people, they don't get any relief, right? It's written in their law saying that you can't give life without parole. There's more than 40,000 people serving life without parole in the state of Florida, and yet none of them are getting relief that the law demands, and it's unfortunate. So about a year ago, I was working with people down at Society First in Florida, and we were trying to look at some options, to be able to force it in. And I think that one of the greatest options, and we haven't gone this direction yet. I think that we're probably going to be working together a little bit more here in the near future. But the 13th Amendment is a perfect amendment to use because if the federal court says, yeah, you got to have a federal issue in order to bring it into federal court, which is bullshit, but nonetheless, if the state says that they can't serve life without parole, and then the state refuses to hear the case, what relief do you have, right? But the 13th Amendment is the case because what the 13th Amendment says, it says neither slavery nor involuntary servitude shall exist except as punishment for crime, whereas the party shall have been duly convicted, right? And the key word is duly. So duly is defined as in accordance with proper procedures, right? So in other words, you can't be enslaved unless you get convicted in accordance with the proper procedures. And so the proper procedures for the enslavement, according to the state court, would be you can't give life without parole. That would be a proper procedure, and it wouldn't be following the proper procedures. Therefore, you are duly incarcerated for life without parole, and that would be a direct violation of the 13th Amendment. So, there are some options I think that Florida would have to be able to move this case into the federal court to be able to be heard, because you have to attach to an actual constitutional violation to do it. Now, another great example is like these drug laws. There's all kinds of people that are getting arrested all across the country for possession of a controlled substance, whatever that controlled substance might be. But the problem is that in an egalitarianism form of government, such as we have, when you go to Article 4, Section 2 in particular, what it says is it says the citizens in each state shall be entitled to all privileges and immunities as the citizens in the several states. So, in other words, if there's an immunity, because that's what it is, you have an immunity to prosecution because you're in possession, right? It's not decriminalized because there's still statutes in the federal laws that say that you can't have drugs, but you are immune to it because the state has said, well, we're not going to prosecute. So it's not a privilege to have it; it's an immunity to have it, right? It's an immunity from prosecution because the state has said we're not going to prosecute, and as a result, you still can't have it in possession because that would be in violation of federal law. But the state has said we're immune. So when it says that the citizens in each state shall be entitled to all privileges and immunities as a citizen in several states, then that means that in the state of Oregon now, you can have any drug at all. You can have possession of heroin. You can have possession of fentanyl. You can have possession of drugs in your personal use because that's what the state of Oregon passed as their law. And for that reason, the citizens of the United States that reside within the state of Oregon, they have an immunity to the possession of drug conviction or prosecution, which means that the citizens in each state shall be entitled to all privileges and immunities as the citizens of several states. So if Oregon has an immunity to the prosecution of drug possession, then the state of New York can't prosecute for drug possession because that would be a violation of Article 4, right? Because if one citizen in one state has an immunity, you must extend that same immunity to all the other citizens all across the country. And so, that's where the dangerous nature of the states creating the laws comes into play because now we have this irregularity, this disjoining of the nation because we don't have equal laws that are spread across the whole country that make all men equal. Instead, we have one state that says, yeah, you get an indictment by a grand jury. This state says, no, you don't get an indictment by a grand jury. This state says that you can have drugs in your possession. This state says you can't have drugs in your possession. Alabama says you can't peaceably assemble for and petition the government for redress grievances, but you can up in Michigan. So if we're going to have a nation where all men are equal, then that starts with the laws treating all men equally across the entire nation. That's what an egalitarianism form of government is. That's why Article 1, Clause 1 of the United States Constitution says that all legislative powers vested in Congress of the United States. Because the Congress in a federal government was supposed to create the laws. They would create the laws together as a group, and then they would federate them out to each of the regional governments for application administration. That's what it means to be a federal government, is to create the laws collectively and federate them out for application administration. That way, if you break a law, you would be breaking the same law that anyone else in the whole country would be breaking. And what's most important is then the judge who works for the state would be able to be neutral and unbiased because he doesn't work for the government entity that's seeking the enslavement. So if the laws are made by the central government and federated out to each of the states for application administration, then the law enforcement who works for the state and not the central government would be able to be neutral and unbiased in their investigation. Then the judge who's judging the case would be neutral and unbiased because the accusation would be coming from the United States of America in the violation of laws. But the judge would be able to say, I don't work for the United States of America, I work for the state. Now you have what's called the separation of powers that exists. So if the United States of America creates the laws, according to Article 3, that the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state in which the crime is said to have been committed. States don't make laws because if they do, according to Article 3, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So if a state creates a law and becomes a party in a cause, the United States of America has jurisdiction, right? There's the separation of powers. So if the United States of America creates the laws, then the state is the judge. If the state makes the laws, the United States of America is the judge. there is a separation of powers. That's why the Constitution, Article 3, says that if the state creates the laws, become a party in the cause, then the Supreme Court of the United States becomes the original court of original jurisdiction. It's the trial court. They are the judge to determine it, because you cannot have the state be the same entity bringing the accusation and judging and investigating and the one that's profiting off the very enslavement of the individuals that they deem a criminal. So, you know, if we want to understand the original intent of the Constitution, or the reason why any of the founding fathers wrote the Constitution the way that they did, we would go to the Federalist Papers, right? And that would provide indication as to their thought process, and why they made the decisions the way that they did. So we know that James Madison is the father of the Constitution. He's oftentimes called the father of the Constitution. We know that he wrote Article 3. So if we want to know why Article 3 says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, if we want to know why he made that provision that way, well, let's find out what he had to say. So when you go to the Federalist, Circular number 10, New York Packet, November 23rd, 1787, the article is titled "The Union as a Safeguard Against Domestic Faction and Insurrection." And in the article, James Madison said, "No man is allowed to be judge in his own cause, because his interest would no doubt bias his judgment, and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time." So a body of men makes up the state. That body of men cannot be both judge and party at the same time, according to our founding fathers, right? According to the very author and father of the Constitution, you cannot have the same body of men be both judge and party at the same time. Now, Alexander Hamilton also spoke of this in the Federalist number 78, and I'm going to butcher what he said, but he said that no man ought to be judge in his own cause. Therefore, they should not be judged in any case in which they have the least fit bias or interest. So Alexander Hamilton spoke about this particular issue in the Federalist number 78. James Madison spoke about it in the Federalist number 10. And we even have the Supreme Court in Martin versus Hunter's lessee from 1816, I believe it was, that spoke about this, and the biases and prejudices that occur when a state is the party in the cause. You guys are welcome to go out and read Martin versus Hunter's lessee. Supreme Court of the United States talk about it. So before I move on to another question, I want to talk for a moment about immunity. I want to tell you guys a little bit of history about immunity. I want you guys to understand the history of immunity, because it's a lie. It's bullshit. It's not true. Okay? And let me explain to you the reason why. Okay? So the very first case that the United States Supreme Court ever heard was a case called Chisholm versus Georgia in 1793. And in this particular case, an individual was suing the state of Georgia. He was from South Carolina. He was suing the state of Georgia for failure to pay bonds, right? And so he brought up this argument that said that a dispute between B and A is most certainly a dispute between A and B. So he was basically pointing out the fact that it really doesn't matter whether you're a petitioner or respondent, that depending on the position that you're in the case, it doesn't change the makeup of the body or the entity that's in the party. And so, but he was suing for under Article 3, the exact same argument that we have today. He brought up. Now, one thing is that in 1793 he successfully litigated it with the argument that a dispute between A and B is most certainly a dispute between B and A. My argument that's at the Supreme Court is that if 1 + 2 = 3 is unconstitutional, clearly 2 + 1 = 3 is also unconstitutional. Simply rearranging the order of the parties does not magically change the representation of the parties. So if Article 3, Section 2 says that in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction, right? Well, if it's unconstitutional to bring the state as a defendant into federal court, right? Then that's what they say. You can't do it, right? You can't bring the state as a defendant in federal court. They tell you you got to use the warden or a person or these other things. But if that's true, then that means that the state can't come as the party as the accuser, as the plaintiff. Because if it's unconstitutional for the state to be a defendant, then it must also be unconstitutional for the state to be the plaintiff. Because it doesn't change, who it is. It doesn't change the makeup of the party depending on the position that the party is in within the case. So if state of Washington, or sorry, if Tanoa M. Downing versus state of Washington is unconstitutional in federal court because the state is named defendant, then state of Washington versus Tanoa M. Downing must also be unconstitutional because it's the exact same parties. And so that's how we actually created the jurisdictional issue in the case that we have, so we can force this to actually be heard, is that we brought up the fact so in the state of Washington, I got more than 4,000 people to petition all at once, exact same writ, exact same writing. I prepared the writ. It was 290 some pages. And then I was the first to file. I filed it first on April 10th, 2019. And then immediately after, we started bringing them in. In between April 10th, 2019 and September 2019, we had over 4,000 people petition the federal court in the state of Washington on this particular issue. Now, I did that because, when the NAACP was doing Brown versus Board of Education in 1958, that was their strategy as well. What they did was they brought a whole massive number of petitions together all at once to just slam the court because they wanted to create irregularities. They wanted to be able to show that this judge did it this way, this judge did it that way, this judge did it, or this court did it. And as a result, now they can find irregularities, and through those irregularities, then they can force it into the Supreme Court's jurisdiction. That's what you want to find. So I brought in a massive number of petitioners between April 10th and September 2019 because we needed to get these irregularities put into place. Now, where we got them at was that me being the first to petition, right? And someone is going around saying that it was dismissed, saying that it was frivolous. Well, that's great. That's wonderful that it says it was frivolous. They wanted to say that it was frivolous because they wanted to keep other people from petitioning because they saw the massive number. Before the end of the first week, I mean, think about it. April 10th to September, we had 4,000 people petition. That means we were getting hundreds of petitions being submitted to the district court every single week. The exact same paperwork. The only thing that changed was the first 3 pages. Everything else was exactly the same. Exactly the same. Nothing changed. That creates the class action suit, right? And so when we hammered the court, then they panicked. They immediately panicked because they saw these numbers coming in. Before the end of the first week, we already had the first 100 in, and then the numbers just ticked up significantly after that. And so the court panicked. And so of course they're going to say it's frivolous. Of course they're going to say, oh, he doesn't know what he's talking about. It doesn't make any sense. He's retarded, whatever, because they don't want this to continue to go, right? They want to be able to discourage people to continue to petition. But we weren't going to be bulldozed like that. But what happened was that the court immediately, they came up and they said, well, you're dismissed, right? But the case that I had was Tanoa M. Downing versus state of Washington, right? Tanoa M. Downing versus state of Washington. That was the parties, that was the case, and it was immediately dismissed. Immediately dismissed, frivolous, whatever, right? Well, after that, the other 3,999 petitioners, after they dismissed mine, before the judge or the court took any action in the case whatsoever, the judge ordered the clerk of court to substitute the respondent from state of Washington to the warden, right? Now, I had everybody petition with the exact same 2 parties that the criminal case was. So if you had a criminal case that was Tom versus or Bob Tom versus state of Washington, then you would use exactly the same parties. No middle initial, no. If it was a middle initial, then you would use it. If it wasn't, you wouldn't. You would use the exact same 2 parties that was in your criminal case that would superimpose over to the federal case. Exact same 2. So if it was state of Washington versus Tanoa M. Downing, then we would bring Tanoa M. Downing versus state of Washington. Exact same 2 parties, written the exact same way. And so I had this going on. All 4,000 people petitioned that exact same way. In fact, they came to me numerous times. They're like, yeah, but writ habeas corpus says that you're supposed to use the warden. Why are you using the state? Well, because when they dismissed my case, the judge stated that the court lacks jurisdiction, right? And he dismissed it. Said frivolous, court lacks jurisdiction because the state is a party. Well, court, if you don't have jurisdiction, then how did you dismiss a case? Because you can't take action in a case that you don't have jurisdiction in. Because if you do, then you create what's called a jurisdictional error, right? So you can call it frivolous, but by that jurisdictional error, the judgment's void. Because anytime there's a jurisdictional error, it results in a void judgment. Go to Civil Rule 60b4. It'll tell you that a judgment is either valid or void. It's valid in all instances except for when the court rendering the decision lacks either subject matter jurisdiction or personal jurisdiction. If it lacks either one of those two things, that is a void judgment, and a void judgment is always and forever void. It can never become valid because the court can never obtain jurisdiction when it lacks jurisdiction. And the Supreme Court just stated, back in January of this year, that a jurisdictional rule can never be waived and can never be. They just flagged me for hate speech. Where's my hate speech, guys? So jurisdictional error can never be waived, can never be violated, it can never be forfeited because the jurisdictional rule comes as a first duty to the court. The court's first duty is to determine whether or not they have jurisdiction. Before they can summons anyone into their court whatsoever, they have to first determine whether or not they have jurisdiction. And if they don't, then they cannot take action in any case. And if they do, then they create a jurisdictional error, which is a void judgment. And that means that I can wait as long as I want to challenge this. But that also means that the only court that I can take it to that can settle it is the court that had original jurisdiction in the case to begin with, which is the United States Supreme Court. So when the district court created that jurisdictional error, now I get to spend time building the case, knowing that all I got to do is just shove this into the Supreme Court's jurisdiction and say, all right, Supreme Court, and at a minimum, the Supreme Court has to address the unconstitutional ruling, the jurisdictional error. Now, what they would normally do is they would normally just reverse it, remand it back to state court or to the district court so the district court could dismiss it constitutionally, lawfully, right? That's what they would normally do. That's what they did in 2004 with Rashul versus Bush. But we were one step ahead of them because I knew that in Rashul versus Bush that it was the same jurisdictional error, it was the same issue, right? And when they got it to the Supreme Court said, oh my God, we don't want to make this ruling, so let's just reverse and remand, send it back so we don't have to hear it. And then when it got back to district court just dismissed it. Dismissed, gone away, right? And the Supreme Court never had to make the decision. I wanted to avoid that. So in the order remanding the case to the United States Supreme Court, I pointed out the fact that, okay, Supreme Court, if you simply reverse and remand this by saying that, yes, it's unconstitutional, that Tano Downey versus State of Washington is unconstitutional because the state is a party, right? And you reverse it, remand it so that the district court can substitute the respondent from State of Washington to whoever else, take jurisdiction over the parties and then dismiss it so that you never have to hear it, then that's fine. But if you do that, then you're automatically going to render the criminal case also unconstitutional because they're the exact same parties. Tano M. Downing versus State of Washington is unconstitutional. Oh, okay. Well, great. Then State of Washington versus Tano M. Downing is also unconstitutional, Supreme Court. So if you simply reverse and remand, then you, by your order, is automatically going to render all the criminal cases unconstitutional as well. So I'm trying to force the Supreme Court to actually make a decision, make a ruling, give the people the rights that they're guaranteed in the Constitution of the United States and the Bill of Rights, give them what they're guaranteed for once in the history of your court, do the right thing, the lawful thing, and enforce the Constitution of the United States. And so going back to Chisholm. So Chisholm versus Georgia, 1793, the Supreme Court, they come out and they say, yep, there is no immunity, all right? And it was a 4-1 ruling on the court because there were 5 justices at the time. So 4-1 ruling. And they said that the states gave up their sovereignty in order to join the Union to subject themselves to the supremacy of the United States Constitution. So the definition of a sovereign state is a state complete in itself, not subject to a higher government's laws. That's the definition of a sovereign state. So when the state of California says I'm sovereign, what they're saying is that they are not subject to a higher government's laws, because that's the definition of a sovereign state. The state of California cannot be sovereign because a non-sovereign state is a state that is not complete in itself, subject to a higher government's laws. So when the state of California, when they entered into the Union, they willfully entered into the Union and they willfully subjected themselves to the supremacy of the United States Constitution. And in doing so, they gave up their sovereignty. And as a result, they don't have the authority to be able to create their own laws and then substitute them for the guaranteed Constitution, because that would mean the state is sovereign and they can do whatever they want. That's not a union. So a union is 2 or more non-sovereign states with a central governing structure, right? That's a union. Now, a confederacy is 2 or more sovereign states with a loose, decentralized governing structure. So today we have a confederacy, right? And we all know today that confederacies promote slavery, right? We know that from our own history and our own Civil War. So, we have a confederacy because these states believe that they're sovereign. They don't believe that they gave up their sovereignty to subject themselves to the supremacy of the United States Constitution, but that's not true. The United States Constitution is the overarching laws. You gave up your sovereignty when you joined the Union, subjected yourself willingly to the supremacy of the United States Constitution. And as a result, you don't have the authority to be able to create your own laws, substitute them for the guarantees of the Constitution, because that would be an act of sovereignty by a non-sovereign state. So um, now there's one other point that I'd like to make real quick, and that is that when you look at sovereignty, there's actually four questions that you ask. Four questions. And the very first question, none of the states can pass. None of them. Because the very first question is a sovereign state must be able to engage in foreign commerce, right? No state can engage in foreign commerce because Article 1 says that Congress of the United States must do it. So when you look at the criteria in the four-step criteria to determine sovereignty of a state, they can't even pass the very first step, which is the ability to engage in foreign commerce. So the states are not sovereign. They're not, because by the very definition, they subject themselves to the supremacy of the United States Constitution. Now, the other thing that's important to note is that every single state constitution within the first article has subjected themselves to the United States Constitution. So, for instance, in the state of Washington, Article 1, Section 2 says the United States Constitution is the supreme law of the land. So the state constitution has itself placed into a position of subjection to the United States Constitution. And as a result, it doesn't matter what the state constitution says because it's in subjection to the United States Constitution. So when we talk about judges that swear an oath to both the state constitution and federal constitution, and that could be confusing, well, it can't be that confusing because if they knew the laws, then they would recognize the fact that it doesn't matter what the state constitution says because the state constitution is subjected itself to the United States Constitution. Therefore, your oath is still with and to the United States Constitution. Don't breach it because it's the supreme law, not the state law. So, I had this conversation with Dakota just the other day where, they're bringing an accusation against him and they're relying upon the state of New Hampshire Constitution. And I said, well, wait a second now. What does the United States Constitution says? Because if the United States Constitution says the opposite, then which law is supreme, right? This becomes what's called preemption. Preemption is when you have a inferior provision of law that functions directly to a superior provision of law. You have to deal with preemption, which means that you take the unconstitutional law, whatever that is, right, and you will replace it with the constitutional law, and then you have to let the dust settle where it may. So, for instance, what we're doing with this whole indictment issue is that when the state of Oklahoma says that the prosecuting attorney can charge by information or indictment as prescribed by law, as it does in Article 2, Section 16, I believe it is, then when it says that, that is unconstitutional. It's unconstitutional because it's an equal protection issue, because what it does is it says, now, that particular provision doesn't operate on its face unconstitutional, but by application it's unconstitutional, because what it says is that it's directing the prosecuting attorney to determine what is prescribed by law. Yeah, you can charge by information or indictment as prescribed by law, right? So it directs them to go out and figure out what it is, but they're not using what they're constitutionally required to have, because the United States Constitution says you got to have an indictment, and yet they say, oh, well, I can use my discretion and use information instead, but that's not what's prescribed by law. And so they're relying upon this inferior state statute. Now, in the state of Washington, where it says no grand jury shall be drawn or summoned in any county, that's obviously a facial constitutional violation. So what we do with preemption is that we go in and we remove the unconstitutional provision in the inferior constitution, and we will replace it with the correct constitutional provision. So when we remove Article 1, Section 26 of Washington State's Constitution that says no grand jury shall be drawn or summoned in any county through preemption, we remove it, we replace it with Clause 1 of Amendment 5. We say no person shall be held to answer for capital or otherwise infamous crime unless a presentment or indictment of a grand jury. Once we do that, then we let the dust settle where it may. And if all of these cases are all relying upon an unconstitutional law, remember, Norton versus Shelby County, an unconstitutional law is not unconstitutional from the moment it's deemed such, but rather from the moment it was created as though it was never created at all, because it was always unconstitutional. So if the state of Washington created a provision in its inferior constitution in 1847 or 1879, I think it was, when they created this inferior constitution as provision, and it functions directly the contrary, then that means that every single criminal judgment that's ever been done by the state of Washington must be removed, because once you remove the provision that's in place and you replace it with the correct provision, what happens is all of those judgments don't exist anymore because they all relied upon an inferior unconstitutional law that the state had no authority to be able to put into place. And that includes the state of California, right? Because California says that they will only hold one grand jury once a month, right? One time per month in every jurisdiction. Now, what happens there is that the prosecutor says, well, you know what? I like this guy because we got a really strong case with him, so we're gonna go with an indictment for this guy, right? But this is a really really weak case over here. We probably can't secure an indictment here, so we're just gonna charge by information and then use duress, coercion, intimidation in order to force him into pleading guilty because we just don't really have a case against him. So what happens there is that the prosecutor has abused the discretionary authority with which he's invested in law to determine who has a right and who does not, which that makes that law unconstitutional. Never, ever, ever can a prosecutor or any other public official decide who gets a constitutional right and who does not, because that would be an equal protection issue. No state shall create any law that does not provide equal protection of the law. So going back one more time, Chisholm versus Georgia, Supreme Court comes out and they say almost unanimous, 4-1, that, hey, the states gave up their sovereignty to subject themselves to the supremacy of the United States Constitution. They even went in to talk about specifically the sovereign immunity issue. So sovereign immunity derives from the theory and the English doctrine that the king can do no wrong. The king can do no wrong. So what it means is that all the laws came from the king in England, right? All the laws came from him. So he can't break the law because he just changes the law. So you can't charge the king with a crime. You can't sue the king without his consent because he has to agree that he broke the law in order for him to have broken the law. Otherwise, he says, well, so the king can do no wrong. And so in English tradition, what was happening was that the king would then grant all of his agents immunity as well, extend his immunity to them so that you couldn't prosecute them. Well, here's where words come into play and some interesting words here. So stick with me here, right? So if the king can do no wrong because he himself creates the laws, right? Then here in America, who creates the laws? We the people do, right? Therefore, the ones that are immune and sovereign are actually us, the people. We create the laws. Therefore, we are the ones that are sovereign. The king can do no wrong. We can't be prosecuted without our consent, right? That's consent, right? So it's by our consent that we permit them to prosecute us because we are the sovereign, not the state. The state can't be sovereign because they don't create the laws. We create the laws. Therefore, it's by our consent that we are sent to prison. It's by our consent that they prosecute us, right? So, but here's the thing, right? They've transferred it. They've made us believe that they themselves are sovereign, which isn't true. And the reason why is because in English tradition, a king was known as nobility. Nobility, okay? They were nobility. They were noble, okay? So here in America, the way it works is if you choose to violate the law, you incur a debt to which you are charged and then called to account so you can pay the debt. Now, these are all very simple accounting terms. Now, the way that debt normally works is if I want to purchase something from a store, a bill will first be generated, which I sign and accept. Then my account is charged and I incur a debt to which I then have to pay. It's a very simple method for transactions to which anyone can understand. However, if the store charges a person's account without billing him first, that's called fraud. You must always bill before a charge is generated. Now, how this applies to this case is that an indictment is called a bill. So absent an indictment, people are being charged fraudulently because they're not being billed first. You must bill in accounting before you can charge. Therefore, when they create a charge without a bill of indictment first, that means that the charge is fraudulent because there's no bill that was created in order to generate that charge, right? So you must have a bill before you charge. And so the way that you initiate a criminal action is through a bill of indictment, a bill. But a king has nobility because you can't bring a bill against a king because he has nobility. That's where that word comes from. That's actually the origin of that word. Is nobility means that you have nobility. You can't bring a bill against a king because he has nobility, and he extends nobility onto all of his agents because they cannot be billed for a crime because they have nobility. Now, where this comes into play constitutionally is that Article 1, Section 9 says that the United States shall not create patents of nobility. Article 1, Section 10 says that no state shall create heritages of nobility. Therefore, nobility is actually unconstitutional. So when you say that you have nobility and I can't bill you for a crime without your consent, you're incorrect, state, because when I go to Article 7 of the United States Constitution, right before every one of the founders signed it, it says This Constitution is ratified by unanimous consent of the states. And in fact, this is the only word that the whole word is actually capitalized in the whole Constitution. Consent is capitalized. You see, the states gave their consent the moment that they willfully entered into the contract with the people of the United States. They gave their consent. If we breach this obligation, you can come after us because we gave our consent. It was made by unanimous consent. So the states already gave their consent. We don't have to go get their consent. They already gave it. It's on Article 7. It's written right there, right before you all signed. It says this is entered into by unanimous consent of the state. So again, so we have nobility as the issue with Constitution, right? You can't have patents nobility, right? Now, an interesting thing is that when you have nobility, you actually have something that's called an honorific. An honorific. An honorific typically goes before your name. So, like Sir Tanawa would be an honorific. I would be Sir Tanawa. That would be a patent of nobility. It would be a honorific of nobility. You know what the sick thing is that these guys actually took the exact word and placed it before their name. The honorable judge, whoever. The honorable judge, whoever. Honorable. That honorable means honorific. That is an honorific. It is a title of nobility. And so these individuals believe that they have nobility, but according to Article 1, Section 9 and Article 1, Section 10, you can't have nobility. You can't. It would be unconstitutional because everybody here in America is subject to the criminal acts. They are fully billable for the crimes that they commit against the people of the United States because we're sovereign, not you, Judge. We are, not you. So again, going back to Chisholm, what happened then was that the Supreme Court decided, yeah, the states are not sovereign. And they gave it up, and so all of a sudden Chisholm won his case. Yay! Everybody's happy. Sovereign immunity doesn't exist. Well, what immediately happened right after that was that the states threw a fit. They're like, well, we didn't give up our sovereignty. We maintained. If we would have known that, we would have never entered into the union. Right? And there was this big up in arms that existed. And right or wrong, what happened was we passed the 11th Amendment, right? 1795. We passed the 11th Amendment. And so, again, right or wrong, it doesn't matter. It was enacted. It was ratified by the people. It is law, right? So the 11th Amendment was put into place. But so before I hit that, so then what happens is we have 100 years of major cases. We have Martin versus Hunter's Lessee. We have Cohen's versus Virginia. We have McCulloch versus Maryland. We have huge Supreme Court cases over the course of 100 years. Huge cases. Every single one of them said states are not sovereign. Every single one of them. Look them up. Every one of them. In fact, most of them even made the statement: the states are not sovereign. Right? McCulloch versus Maryland. And the Cohen's versus Virginia, they all state that states are not sovereign. But then you fast forward to 1890, and it was a case called Hans versus Louisiana. It was by the Waite Court. Now, Waite was well known to be a slave sympathizer, right? He wanted the slavery institution to continue, right? He came from, I believe, Tennessee. So he was a slave sympathizer. He put into place numerous rulings that undermined the Reconstruction Amendment and has now led to another 180 years of oppression of the people and certain minorities within our society because of his acts that were intentional to undermine the very laws that we put into place to try to prevent this thing from happening again. We talk about the 14th Amendment. We say that it's not valid, that it, whatever. I'm not going to argue with that. I'm not going to refute that. But what I'm going to say is that the 14th Amendment had good intentions. It had good intentions, and if it were actually followed with its intentions, then it would free up a lot of these issues because the 14th Amendment was sealing up two major horrible cases: Dred Scott versus Sanford and Barron versus Baltimore. Right? Blacks are not people. Right? We wanted to make sure that from henceforth that is not the foundation of our law any longer. Right? So we technically overruled Barron versus Baltimore, where the Supreme Court said that blacks aren't people. And so that was the first one. And then we went back to Barron versus Baltimore in 1833 and we said, oh, no, you know what? Every single person within the jurisdiction of the United States from henceforth is going to be guaranteed every single thing in the Bill of Rights. That was what the 14th Amendment was intended to do. And we know that because Congressman Bingham, who introduced it onto the House side, and Senator Howard, who introduced the bill onto the Senate side, both of them made the statement when they introduced the bill that that's what the intended purpose was. From henceforth, all persons born or naturalized in the United States are going to be people, right? They're going to be people. So we wanted to make sure that everybody's a person from now on. That was the intended purpose. So, we we can argue about whether or not it exists, but the reality is that it had very, very good intentions. But what happened was that Chief Justice Waite, when a number of different rulings, including the slaughterhouse cases, the civil rights cases, the Hans versus Louisiana, a number of these cases that he did, what he did was he actually completely disregarded, sidestepped, didn't even review the Congress's statements that were made on the floor for the intention of the 14th Amendment, and he intentionally sidestepped it and went back to Barron versus Baltimore and drew it back across and stated, yeah, well, the Bill of Rights are not protected against the states, or are not guaranteed by the states. He brought that back in, even though we technically overruled it with the 13th, 14th, and 15th Amendment. He brought it back in intentionally, and that is what's led to it. So, he had no authority to do that. We made a decision. We enacted a particular provision that we wanted to ensure that all men were equal once again, because you know what? I don't believe that the people are the cause of these problems. Our government is the cause of these problems. Racism, again, it has no place within our society. Economicism has no place within our society, right? We are a nation of good people as long as we accept the fact that we didn't do this. We didn't cause this. This isn't our fault, right? It's not natural to hate another human being based upon any criteria whatsoever. That is created, it's learned because that creates conflict. Conflict creates crime. Crime creates criminals, and criminals make them in their institution a lot of money. And we got to get away from it, right? We got to understand that we didn't cause this. This wasn't our fault. So what happened was 1890, Hans versus Louisiana comes forward, and Hans was suing the state of Louisiana, right? He lived in Louisiana. He was suing the state because what happened was the 11th Amendment. What the 11th Amendment says is it says that a citizen of one state cannot sue a different state. That's all it says. It's all it says. Read it. That's all it says. Okay. So what it did was the 11th Amendment technically overruled and overcame the Chisholm issue, where an individual from South Carolina was suing Georgia, and they said, oh, no, you can't have that happen. You can't sue a different state, right? A citizen of that state can't sue this other state. So the 11th Amendment technically overruled part of the immunity issue, and it said that you can't sue a different state, but it said nothing at all about suing your own state. Nothing at all. Go read it. It says nothing at all about suing your own state. But what it did was it intentionally corrected the Chisholm issue, and it made it so that a citizen in one state cannot sue a different state. Fast forward to Hans versus Louisiana, 1890. And what happened there was that the Waite Court, once again, known to be slave sympathizers, known to want to advance the slavery institution, what they said was, you know what? We don't read the 11th Amendment literally. We read it figuratively, and we believe that its interpretation was that the states are sovereign. So they said, we don't read it literally. We read it figuratively, and we believe that it means that states are sovereign. Thus, sovereign immunity is born. Thus, sovereign immunity is born. And now, from 1890 on, we believe that states are sovereign, even though nowhere in the Constitution does it say that you can't sue your own state. It does say in the 11th Amendment you can't live in one state and sue a different state, but it does not say anything at all about suing your own state. However, the Supreme Court came out and said, oh, yeah, it doesn't say it, but we think that it implied that. Well, the problem is that the Supreme Court of the United States has no authority to be able to alter, amend, or destroy the Constitution of the United States based upon judicial fiat, right? If you want to change the Constitution, you got to go back to Article 5, determine how to do it, and follow those procedures. And that doesn't come by way of the Supreme Court of the United States saying, well, you know what, it doesn't say it, but we want to do it anyway, all right? It doesn't work that way. So one of the things that we have in our advantage here when it comes to sovereign immunity and overcoming it here is, one, Supreme Court, you have no authority to be able to alter, amend, or destroy the Constitution. So what you did was unconstitutional because you amended the Constitution in 1890 without lawful authority, because all legislative power is vested in Congress of the United States. And the separation of powers means that the judicial branch has no authority to be able to say, we're going to do this. But we can also go to the Supreme Court itself, because in 1995, there was a case, 1997, there was a case called Seminole Tribe of Florida versus Florida. And it wasn't that the Supreme Court of the United States overruled sovereign immunity, but what is telling was the dissension. It was written by Justice Souter. And what Justice Souter said is he said there appears to be two versions of the 11th Amendment that exist. One enacted by the people in 1795, the other conceived by this court almost a century later. So the dissension written by Justice Souter says that the Supreme Court of the United States conceived the alteration of the Constitution and it doesn't exist. One enacted by the people in 1795, the other conceived by this court almost a century later. The judicial branch had no authority to conceive law. That would be legislated from the bench. That would be a separation of powers issue. So Justice Souter pointed to it directly in 1997 in that case, Seminole Tribe versus Florida, saying that, yeah, the Supreme Court conceived this law. It has nothing. It's not even there. It doesn't even exist. So it was by case law that we see the creation of sovereign immunity, but it has nothing to do with the Constitution. Nothing at all to do with the Constitution. So judicial branch, if you want to change the Constitution, I would suggest that you present your case to the people, right? Get the people to agree to your argument, and thus we alter the Constitution in a lawful manner. And otherwise, what you did was an act of sedition created by traitors of the United States, right? So we can go back to the Waite Court and we can say, wait, you never had authority to be able to do that because what you did was an act of sedition, because sedition is the speaking or writing of words such as law established in order to cause disaffection of the Constitution to procure its alteration in an other than lawful manner, okay? So the Supreme Court doesn't have the authority to be able to alter, amend, or destroy the Constitution of the United States. Those are the two questions. We have two questions that we're bringing to the Supreme Court that we have to get addressed. They're both rhetorical. We don't even need them answered, right? They already know the answer. That's why they're silent on it. The first question is, do states have the authority to substitute their own alternative legislation for the provisions and guarantees of the Constitution of the United States of America? No, states don't have the authority to do that. Great, awesome. Now we can get rid of all these state statutes that are all unconstitutional, all these state constitutional provisions that are all unconstitutional, all these states that say we're sovereign, right? And get rid of all that bullshit from question number one. Question number two is, does the judicial branch have lawful or constitutional authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution of the United States of America? The answer is no. So now we can go to the judicial branch, remove all of this bullshit rulings that they put into place that's contrary, that amended or altered the Constitution of the United States based upon their legal realism and judicial fiat. We can go back and remove all that, place the Constitution back in its foundation, have it come as the overarching laws that go across the entire United States. And in doing so, we will then let the dust settle where it may. And if the Supreme Court of the United States made a ruling in 1833 that says that criminal defendants don't get the very guarantees that they're entitled to and written and enumerated in the Bill of Rights because we don't want to give it to them, as they did in Barron versus Baltimore, United States Supreme Court, then that fraud of court that was introduced, that fraud that the Supreme Court, the highest court in the land, introduced fraud, and that fraud is now permeated to every single court across the entire nation, which means that every single thing that all these courts do is going to be unconstitutional because it derives from this act, this ruling that was put into place by the Supreme Court of the United States that was clearly unconstitutional because they directed all of the courts within the purview of the Supreme Court that they don't have to follow the Constitution of the United States. That's what put us into martial law. A lot of people talk about martial law. Martial law derives from martial court. We have been in martial law ever since Barron versus Baltimore was put into place because no one in the history of our nation has ever been protected by all of the provisions and guarantees of the Constitution because, one second, guys. Okay. So because the Supreme Court of the United States, the highest court in the land, came out and made the statement or directed all the courts within its purview to not give the very rights that are guaranteed to the people of the United States in Barron versus Baltimore. And what happened there was that Marshall suspended statutory obligations because the Constitution is nothing more than a statute that created obligations. So when they say that we can suspend statutory obligations, which is what martial law is, they suspend statutory obligations. And that's also what happened in the Emergency Powers Act, right? That allowed for COVID to be able to lock everything down because the Emergency Powers Act says that the governors have the right to be able to suspend statutory obligations in certain emergency conditions. Well, that's an oxymoron, right? How can government suspend statutory obligation when the Constitution is a statutory obligation? So when you say that government can suspend statutory obligation, what you're saying is that the government can suspend the Constitution of the United States. That's what happened with COVID, right? That's what happened when the establishment of the Emergency Powers Act went into play. When you read the Emergency Powers Act, that's exactly what it states. It says that the governor can suspend statutory obligations, which means that the governor can suspend the law. Now, our founders and forefathers would have never created a document that guarantees rights and limits powers, but then in the same breath permit the very powers that are to be restrained to be able to be suspended at their will. That doesn't even make sense. Because if we created a law and a constitution that guarantees rights and limits powers, then how can those with power suspend the very power that restrains them? Doesn't even make sense. So martial law has no validity. But martial law was created by the martial court, right? And so that's where those words come into play as well. Um, but sovereign immunity does not exist, right? And when you look at the history of sovereign immunity, you can see that the judicial branch has no authority to be able to alter, amend, or destroy the Constitution of the United States based upon judicial fiat, based upon a ruling. And when they did in 1890, that would be unconstitutional. Now, one last point here. The reason why the Supreme Court made the ruling in Hans versus Louisiana is this, okay? If the 13th Amendment transferred slave ownership from private party to public party, right? So no longer are people the slave owners. Now the state is a slave owner because the 13th Amendment said that you can't have slaves unless it's a punishment for crime. Well, who becomes a slave owner under the 13th Amendment? The states do. The states are the slave owner. That's why the states have for-profit businesses in every single state where they go and they collect people, our citizens, the weakest, most vulnerable in our society, and they put them into these institutions. They force them into involuntary servitude so that they can generate revenue, make T-shirts and sweatshirts for 30 cents an hour in these institutions that we call sweatshop in China, but prison here in America. So the slave owner is now the state. So in the case Dred Scott versus Sanford from 1857, which was the precursor to Civil War. This was what actually caused the Civil War to finally just blow up. What happened was that Mr. Scott, who was a slave, he was brought from a slave territory into a free territory by his master, by his owner. And when he got into free territory, he said, "Man, I'm in a free state. I'm going to petition the Supreme Court for my freedom because I'm in a free state. I can't be a slave anymore because I'm now in a free state." So he petitioned the Supreme Court, said, "I'm in free country. I want my freedom." And the Supreme Court said, "Holy shit. If we make this ruling, then we're going to have to let all these slaves go. We're going to open the floodgate. We don't want to do that. So how can we keep from hearing this case?" Because they knew if they heard the case that they would have to make a ruling consistent with the law, because that's what the Supreme Court has to do. They knew that they were going to have to rule in favor of Dred Scott, and they didn't want to do it. So instead, they had to figure out a way to where they didn't have to hear the case. So to have standing in federal court, to have standing in the Supreme Court, you have to, one, be directly impacted by the law in question, or two, be a person, right? So clearly he's a slave. So clearly he's impacted by slave law. They can't get around that one. So how can we make him not be a person? Well, what the Supreme Court of the United States said in 1857, written by Chief Justice Taney, Robert Taney, who was a traitor, by the way, what he said, and I'm sorry, you guys, if this is offensive to you, but I need you to understand, this is the very words that was stated by our Supreme Court justice in a case that is still standing Supreme Court precedent today. He said that blacks are not and were not intended to be included under the word citizen in the Constitution. Blacks are so far inferior that they have no rights, which the white man was bound to respect. Slaves are private property protected by the Constitution. So that was the decision written that anybody can read by the highest court in the land and the highest member of the highest court in the land, and yet that case is still cited every single day here across America. Is that what we believe in, right? When they say that person and citizen are synonymous with one another, right? Person and citizen are synonymous, and they say that blacks are not, and we're not intended to be included on the word citizen in the Constitution. It means that if you're not a citizen, you are not a person. So, Mr. Scott, you're black, and because you're black, you are not a person, and as a result, you do not have standing in federal court. We don't have to hear your case. Dismissed. Go away. Go back to the state. Argue with your slave owner about your freedom. And that's what they did. They didn't want to make the ruling. So they dismissed it by saying that blacks are not people. And in doing so, they didn't have to make the ruling because they didn't want to open the floodgates to it. And that's what actually kicked off the Civil War. Well, Chief Justice Waite in 1890, he was a slave sympathizer. And he was lessons learned from Dred Scott versus Sanford, right? Well, he didn't want any slaves to ever get as close as Dred Scott did to their freedom. So the question that Dred Scott asked the court was, do slaves have the right to sue in federal court for their freedom? The Supreme Court said no, because slaves are private property protected by the Constitution, because blacks are not people. So go away. You don't have standing in federal court. You can't bring a case to us. We don't have to hear it. Dismissed, right? So the question was, do slaves have the right to sue in federal court for their freedom? They said no. Well, in order to so when slave ownership was transferred from the private party to the public party, when it was transferred from corporations and individuals into the state, now the state is a slave owner. Well, first off, um, how do we make the slave owner immune? Right? How do we make it so that slaves can't sue in federal court for their freedom? Well, I know. Let's grant states immunity. Let's make them immune. And that's the reason why Waite made that decision, was because he didn't want slaves to ever get as close as they did in Dred Scott. So what he said was that slaves cannot sue in federal court for their freedom because the slave owner is now immune. State's now immune. So you can't bring a case to federal court because your slave owner can't be sued because he's immune. That's all it was. So he took Dred Scott, he memorialized it, and he said, I'm never going to permit slaves to get that close because slaves cannot sue in federal court for their freedom because the slave owner is now immune. And that's why you're enslaved forever. Once you're enslaved into the state, you can't sue in federal court for your freedom because you don't have standing because the state's immune. Slave owner's immune. Now the other issue was that there was another issue that how can a state, being an entity, own property? Because if slaves are private property protected by the Constitution, how can a state own property? So that was another dilemma that the court had, that Waite had, that he needed to overcome. He's like, well, what are we going to do here? And he found the solution in the case called Santa Clara County versus Southern Pacific Railroad. So in Santa Clara County versus Southern Pacific Railroad, what happened was that right before the oral arguments were brought up, right before oral arguments started, Chief Justice Waite made the arbitrary statement before anybody was there. It wasn't even it wasn't even a question or a motion submitted to the court. It was a statement that he made before oral arguments where he said, we're all under the belief that this corporation is protected by the Equal Protections Clause of the 14th Amendment. So he said that a corporation is now protected by the Constitution. Well, only people have rights. Constitution creates rights. The 14th Amendment preserves rights. And so as a result, corporations are now considered people, right? This is where the whole concept of corporations become people because of Santa Clara County for Southern Pacific Railroad, because Chief Justice Waite said, we're all under the belief that this corporation is protected by the Equal Protection Clause of the 14th Amendment. Now, the reason why he made that decision and made that statement was a state's nothing more than a corporation, guys. And if a corporation can't own property, only people can own property. We got to make a corporation a person. We got to grant corporations personhood. And so that's why he made that decision. That's why he made that statement, was because he needed to protect the slave owner, being the state, from and give it the ability to own property. And so now we have this concept of states' rights that's immediately brought into play. This is where states' rights actually come from. States don't have rights. That's another oxymoron. How can a state have a right when only people have rights, right? The Constitution's purpose is to establish rights and limit powers. Establish rights, limit powers. People have rights, government has powers. So when you say that states have rights, what you're saying is that the very government that has powers also isn't equal to a person because they have rights. So states' rights is not actually good. It's a bad thing because government has powers. States have powers, people have rights. But those powers are intentionally limited in order to preserve the individual rights. So when you permit states or governments to have powers or rights, then they're equal to the people. Now they can own property. Now they can sue in federal court. Now they can sue in whatever court. And that's where, we get this entity being a corporation, that's able to bring a charge against us because only a person can bring a charge against someone else. But now corporations are persons. And because the state is nothing more than a corporation, and Chief Justice Waite made the statement in the Santa Clara County versus Southern Pacific Railroad that corporations are protected by the 14th Amendment, therefore corporations are granted personhood. Now the state is able to bring charges against you. But the issue of personhood was established and was played out in 1850 or 1958 in the Brown versus Board of Education case, because there's 5 criteria to personhood, 5 of them made by the Brown versus Board of Education case. The very first one, no state can meet the threshold, and that is it must be self-aware. States aren't self-aware, so they can't have personhood. The Supreme Court already made that decision in 1958, and yet here we are today, challenged by an entity, a body of men that calls themselves a person that's actually a corporation. But because of the Supreme Court's decision in 1887 that says that, yeah, corporations have rights, now it granted personhood onto the corporation. Now the corporation can bring a suit against you because it's considered a person, and so on. So, that's roundabout way of getting to where we are today. And hopefully you guys can understand that a little bit better. But now here I am. Uh, so I'm going to scroll down here for a moment. Let's see if I can find something else to talk about a little bit here. Hope you guys are getting something out of this, guys. So I hear this every day. The 14th Amendment was never ratified. You guys, I'm not going to go into. I'm not going to go into that. I'm not going to argue. The merits of the reality of it. But just keep in mind here two things, please. Keep in mind two things. One is the 14th Amendment wasn't bad. Go and read what Congressman Bingham said. Go and read what Senator Howard said. Go and read what the people of the United States were bringing forward in their intention of what the 14th Amendment was supposed to do, right? It was going to technically overrule Barron versus Baltimore and declare that every single person is guaranteed every single right secured by and enumerated in the Constitution of the United States, particularly the Bill of Rights, because they went through and they read every single one of the rights within the Bill of Rights, because the court had found out that ever since 1833, the Supreme Court of the United States was not giving those rights to the people. So they wanted to make sure that everybody had all those rights. But look at it today. Even today, right now, today, you still are not protected by the Bill of Rights because they still have not addressed the issue from 1833. You don't get an indictment by a grand jury because in 1833, the Supreme Court of the United States said you don't have to give it to the people, right? It's never been incorporated. That's why I say that what we're fighting here, like what we have to overcome here, is that this is the last provision of the Bill of Rights to be incorporated. All the other individual enumerated rights have been incorporated in from the Bill of Rights, incorporated against interference by states. This is the last one in the Bill of Rights to be incorporated under the incorporation doctrine. The last one was in 2019. It was the excessive fines clause of the Fifth Amendment or of the Eighth Amendment under the Timms versus Indiana case. The grand jury provision is the last provision of the Bill of Rights to be incorporated. Once we incorporate this, then for the first time in the history of our country, every single person will be protected by every single right secured by and enumerated in the Constitution of the United States, regardless of where they choose to reside within the jurisdictional United States. That's what we have here. That's what we're looking at here. This is going to be the first time in the history of our country that every single person is going to be protected by every single right secured by and enumerated in the Constitution of the United States. That's a big deal, you guys. It's a big deal. So, the 14th Amendment isn't bad, right? It's not bad. It had good intentions, but it was misconstrued through the weight court, through the judicial branch, because again, the judicial branch is not what we think that they are. Of the first 28 justices that served on the Supreme Court, 22 of them owned their own slaves. The foundation of the justice system is, in fact, slavery. In fact, every single judge is in the business of enslaving people because the 13th Amendment made synonymous prisoner and slave. They mean the same thing. Every single judge is a slave owner, right? They have a degree in enslavement because if a prisoner is a slave and a slave is a prisoner, according to our laws, which they are, right? The Fugitive Slave Act, the 13th Amendment, you can't have slavery unless it's a punishment for crime. Therefore, if you're punished for crime, you become a slave. Therefore, a criminal is a slave. A prisoner is a slave. They mean the same thing. That's what they're talking about. When they say a slave, when they say a criminal, those two things are interchangeable. Therefore, if you have a degree in making a person into a criminal, such as adjective law, such as a Juris Doctorate, you have a degree in enslavement. That's what it is. You've been trained and taught how to make a person into a slave, right? And we can't sidestep that any other way, because if you are trained to make a person into a criminal, and the 13th Amendment says that a criminal is a slave, then I'm sorry, it is what it is. Your degree is in slavery. That's what that is, and that's what you make. You produce slaves. So a judge is simply a person that enslaved. This institution that they have today is the institution of slavery. Every single person with a Juris Doctorate has a degree in enslavement. Every single judge is simply in the business of buying and selling slaves. That's all it is. The whole system, because the system is built upon the slavery institution. Because slavery is and has always been the foundation. Because we've been relying upon the judicial branch, who has never, ever, ever actually put into place and enforced the laws that set free, because when you set free, it goes against the institution that they have. Do you think that the first 28 justices wanted the slavery to go away when 22 of them owned their own slaves, and yet they build the foundation of the law because we're told that we're supposed to use case law because stare decisis says that judges determine what the law is, right? And so we're to rely upon them. So we go to the foundation being that blacks aren't people, right? That's our foundation. Like that's what we're supposed to listen. How is that at all constitutional or consistent with the American principles and values, right? I mean, that's why I fight the shit that I fight, is because look at what they put into. If the foundation was created by slave owners, 22 of the first 28, then we can understand why we're in the business of enslaving today, because the foundation is founded upon slavery. So let's go back to the foundation and say, that's not what we believe in. We believe in the Constitution of the United States. Get that shit out of there. Judges don't make law. They make rulings. And rulings, when you call a ruling law, it's not valid. It's not true because it's made by a branch of government that has no authority to be able to create law. So let's get rid of all that shit that judges made, that slave owners made, that is geared toward enslavement because that's what your degree is in. And let's put what we believe in at the foundation. Let's put what we believe in there into place. Let's put the Constitution, the law that sets free, let's put it there, and let's let the dust settle where it may. So the 14th Amendment, whether it was ratified or not, it had good intentions, okay? And I'm relying upon it heavily for the work that I'm doing. Because again, one of the provisions of the 14th Amendment, and there's lots of different provisions, right? But the one that I'm relying upon is that no state shall create any law that shall abridge the privileges and immunities of United States citizens. So when the Supreme Court comes out in 2019, in a case called Timms versus Indiana, and they say that the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference from states due to their codification within the Constitution's text, then what they're saying is that anything that's written in the Bill of Rights, the first 10 amendments, anything that's written there is at a minimum what is guaranteed to every single United States citizen. Therefore, no state can create any law that will take away any of those things within the first 10 amendments. That's what they said in 2019. So when a state enacts a law that says that we can take away an indictment by a grand jury, we can substitute our own law for this guarantee that's written and enumerated within the Bill of Rights, I can say, oh no, 14th Amendment says you fucking can't do that, because no state shall create any law that shall abridge the privileges and immunities of United States citizens, and the privileges and immunities that's incorporated or that's written and enumerated within the Fifth Amendment is at a minimum what's guaranteed to every single United States citizen, and you have now deprived millions and millions of people the very thing that they're guaranteed at a minimum according to the Supreme Court of the United States in 2019. So through the 14th Amendment, we can provide enforcement back to the states and say, yes, no state shall create any law that shall abridge the privileges and immunities of United States citizens, and the privileges and immunities of United States citizens are those that are enumerated within the first 10 amendments. Therefore, any state that creates a law that removes the indictment by a grand jury would be clearly a violation of the 14th Amendment. So now we can hammer the state and say, no, state, you can't do that because the 14th Amendment puts it in place. Now, because we're in the election cycle right now, we've got an unusual amount of power, And the reason why is because the last provision of the 14th Amendment, the last provision says that the legislative branch shall have the power to enforce this article. Now, typically the legislative branch doesn't enforce the law, right? That would be a function of the executive branch. The executive branch is responsible for enforcing the law, but not if it's a violation of the 14th Amendment. If it's a violation of the 14th Amendment, then the United States Congress, the legislative branch, is responsible for enforcing that law, which is why I'm back here in DC, which is why I'm now going to each one of these senators and these congressmen. I'm meeting with their agents and I'm informing them of this particular criminal conspiracy that exists, because guess what, lawmakers? You guys have a constitutional obligation to address this and enforce this. And if you don't, then you are all now culpable and in this conspiracy. So the reason why I say we have an unusual amount of power right now is because they have a constitutional obligation to enforce this particular crime. If a state creates a law that violates or abridges or diminishes any of the rights guaranteed by the Bill of Rights, then the legislative branch has a constitutional obligation to enforce this crime, to enforce this law. And in doing so, I have gone through all these states, 33 states, and I've notified all of the executive officers that they are all on notice. You guys are all committing a crime. And then I went back and I provided notice to the Supreme Court in 33 states so that all the judicial officers are now on notice that they're committing a crime. And now I'm in DC going to all these legislators, right? The people that are constitutionally obligated to enforce the law. And I'm saying to them, hey, we've notified all these guys of this criminal conspiracy, right? And now we need you to enforce the law. And if you don't, then you're going to have a very difficult time getting reelected if my message actually makes it out into the public domain, right? If because they're very effective right now at controlling me, right? They're controlling my algorithms. I am having a very difficult time getting this message out, which is why I'm asking you guys to help me. We need to spread this information, spread my video, spread this info, because there's a number of different reasons why this could take off. This could take off quickly. If I hit national news anytime within the next 2 weeks, then every single one of these legislators who are up for re-election right now, they will have to take action. They will have to do something about it, because they will not get reelected if I'm able to say to the public that, hey, I notified you, Senator. I told your agents that of what was going on, and you chose to do nothing about it. So right now, these legislators, they're all taking a gamble. They're being really quiet about this. Yeah, they're being nice. They're meeting with me. They're talking with me, but they're talking with me to kind of get a little bit of intelligence, find out where I'm at, what's going on, because they don't want to actually do something about this. They don't want to. They're hoping and they're praying that my information doesn't get out there, because they're hoping that they will be able to just get away, that it'll be swept under the rug, because after the election, guess what? Nobody cares. They're already elected. But right now with the election cycle, if a scandal like this comes out, if the public hears about the fact that the judicial and executive branch is committing massive amounts, that they're not even following the Constitution of the United States, that they've all been informed and they've chosen to do nothing about it. The Attorney General of the state has completely been obstinate and has refused to even do anything and even consider it. The Supreme Court has refused to consider it. They both remain completely silent on the issue after being notified and informed and served. Because I have video, I've served every one of you all seen it, right? It's all available here and on Rumble, right? I've served the agents, right? They know about it. Every one of them know about it. Hell, I even went into the Department of Justice here in the Washington D.C. and nobody gets in Department of Justice without an appointment, and I just happened to get in because they thought, well, he looks like a U.S. attorney. And I didn't say anything. All I said was that I have evidence here that I need to deliver to the Attorney General. When they say, oh, well, this guy must be an investigator because he's got evidence. Well, yeah, I do have evidence. It's the form of an affidavit, right? And so they let me in, right, without an appointment or anything. So now I'm in the Department of Justice building, which nobody's supposed to be in, and I'm sitting there, and they're like, well, you got evidence? Okay. And they called up the United States Attorney General, called up his chief of staff, and sent him down to collect my evidence. And so now here I am sitting, and he's like, well, how did you get in here? Who are you? And I'm like, well, here you go. You've been served. So, so we provide service even on the United States Attorney General here in Washington, D.C. They've been notified and they've chosen to do nothing about it. And as a result of choosing to do nothing about it, now we need to get the other branch to take action. We have to get the legislative branch now because of the selection cycle. Because if I can get this out in the public domain, if the public will hear of what I've done, right? The service that I've already provided, the work I've already done, including on behalf of Mr. Trump. I didn't do that politically, but I did that because if he has the power to be able to bring a massive amount of attention to this issue, because that's what we need. We need a massive amount of attention brought to this issue very, very, very quickly, right? I served on behalf of Mr. Trump on the state of New York because he was denied his right to be able to confront his accusations in the grand jury. By that crime alone, that negates and renders void his whole judgment. The judgment isn't valid. It doesn't even exist because the state committed a crime in the pursuance of it when the accuser, Stormy Daniels, conspired by and between the prosecutor to deny the accused the right to be present to confront the accusations against him. That's a crime. And by that crime, it renders void everything that happens after that. There is no judgment or conviction that's in place against Mr. Trump. It's not valid. None of it's valid. Because anytime the government commits a crime in the pursuance of an outcome, that outcome is unconstitutional. It's void because wrong will always produce wrong. Only right can produce right. So if you commit a crime in the pursuance of an adjudication, then by your criminal acts state, you render a criminal judgment, an unlawful judgment. Mr. Trump's judgment is invalid. But the thing is that we served on behalf of Mr. Trump at the Attorney General, and I served at the Supreme Court on his behalf. Both of them have been notified that Trump's conviction is unconstitutional and void, right? If Mr. Trump, if Mr. Trump were to get knowledge of this information, if we were to hear about the things that I've already done to help him, right? Whether or not he gets elected, that's irrelevant. But he has the power to bring a massive amount of attention to this issue, massive amount of attention, because he himself will benefit from the work that I'm doing. I did that because all of you need help, because we need to get somehow to be able to get the power that we need to be able to overcome this issue. And if he has that much power, because he could call a press conference tomorrow. If he hears about the stuff that I've already done on his behalf at the state of New York, and he says, that sounds pretty good. I kind of like to take advantage of that, because that would render my conviction void. There wouldn't be any sentencing. All this would be done all by law, and all of a sudden, none of this is all moot, right? And this close to the election, right? If he got behind this and behind what I'm doing, then guess what? Tomorrow I could be standing in front of the Capitol building having a press conference, and we would instantly have 30 million people behind us, because all those 30 million people are all interested in seeing Mr. Trump's. I have 30 minutes left, guys, so I'm going to get off in about 10 minutes. But so if Mr. Trump decided that he wanted to get behind this, right, if he likes the things I did, right, and he wants to get behind it because, it would render his judgment void, then all of the people that are behind him in the campaign, they would all immediately get behind this issue, right? And we would instantly have the power we need to shove this directly into the Supreme Court of the United States and be heard, because he would benefit directly from this. You see, so we have a great deal of power. And so, like I said, whether or not he gets elected, that's up to the people. That has nothing to do with me. What I'm trying to do is I'm trying to overcome an issue so that we can help all of you, right? I'm trying to find a way to be able to make this happen on your behalf. And if we can use his power and the situation he's in, because a crime was committed against him, no matter what, a crime was committed against him, and the judgment's void. There's no doubt about it. I could argue that in my sleep, and we could render it void in an instant, which means the sentencing wouldn't be valid, none of it would be valid. But if this happened to him, and this is the exact same thing that's happened to millions of you, then why would we not take advantage of the situation and say, you know what, let's use Mr. Trump's power to say, hey, you can get behind this and thus nullify and void your judgment. And in doing so, we get the power that we need to provide relief for all of you, because the same thing that happened to you happened to him, yet he has the power that none of us have. So we're trying to find a way to get in, and it could come by Mr. Trump getting behind this. We don't know. So what I'm saying is that we never know who needs to hear this information, right? I have the videos out there explaining what I did for Trump. I have the video out there that explains what I did for everyone else. All this video is out there. The explanation as to why it's void is out there. Explanation as to why your judgments are void is out there. My videos, it would be very nice to get them spread. We never know who needs to hear them, because this situation, it could change in an instant. The difference between today and tomorrow is one of the Trump's advisors saying, I kind of like what he's saying, because he's kind of right there, right? And if I kind of like what he's saying, let's go ahead and introduce it there. Let's get behind this. Let's void and nullify Trump's judgment, and let's get 30 million people behind this so that we can push this into the Supreme Court of the United States, because they say that it only takes 2% of the population, and you can change anything here in America. 2% of population. What is 2% of population? That's 6 million people, right? There's 30 million people behind Mr. Trump that would love to see his judgment reversed, right? We got the numbers. The numbers are there. We can do this, but we can only do this if it happens in the next couple of weeks. We need to push this through the election cycle, because this is the time. The time is now. We can overcome this issue, and for the first time in the history of America, we can make this happen, because the very person that will benefit from it has the power to bring the people that we need behind this, backing it, to say, yep, we want his judgment overturned, and by doing so, we can overturn all of your judgments. We can overturn all your judgments. And my argument can be made. It will be heard by the Supreme Court, and we can do this. but we need to push this before the election campaign cycle. And that's why I say that we have an inordinate amount of power right now, because the legislative branch is actually responsible for enforcing this particular issue. They have a constitutional obligation to do so. So when a senator says to you, I'm sorry, there's nothing I can do about your child that's been taken from you, I don't have jurisdiction, I'm going to say bullshit. Not only do you have jurisdiction, but you have a constitutional obligation to deal with this, because enforcement of this particular law would fall upon the legislative branch. And this is the only instance in which the legislative branch enforced the law, but it clearly states that you, legislative branch, has the authority to enforce the law or enforce this particular article. So if a state creates a law that abridges any of the privileges and immunities of United States citizens, and guess what? The executive branch doesn't enforce the law. Police don't enforce the law. The legislative branch does. So we have the power right now to be able to go to all these legislators and say, you know what? If you want to be reelected, you can gamble. You can take the chance that maybe I won't be heard. Maybe the next couple of weeks I won't be able to make this be heard. But I'll tell you what, God doesn't make fools. He didn't put me here in this position right now with the knowledge I have. He didn't lay out and pave the way that we have, build this deck of cards, or this house of cards that we have stacked up right now that could literally fall at any instant. Because the only thing we need is either one of my videos to go viral, and all of a sudden we get millions of people that have seen it, and they're like, well, I kind of like what he's saying there. Two, right, that the news calls me up and says, well, I heard that you were out there serving 33 states. Great. Now we've got national news, and I can bridge that across. Or three, Trump hears about this and says, you know what, I kind of like that. Let's get behind it. There's three major paths that will bring this information to the forefront. And if this goes into the forefront, I guarantee you, every single legislator that's up for re-election right now, that's out campaigning right now, every single one of them will have to get behind this. Have to. Because if they don't, then I get to say that they are criminals and traitors, and they're refusing to fulfill the constitutional obligations that they have codified in the 14th Amendment of the United States Constitution. So it's 9:37, you guys. I know I didn't get through very many questions once again. I hope you guys got some good information from this. We're going to try to do this every single night. This is only the second time. It looks like I got one more time, Dakota, before I can get you on as a shared guest. I hope that tonight was beneficial to all of you. I'm going to call it a night because the street lights are on. Murder, She Wrote just ended, and I usually go to bed right around that time. So this is way past my bedtime, guys. So I love you. Thank you so much. Please continue to follow. Please share the videos that we have. And please just know that we never know who needs to hear this information. We never know. We're all going to do our part. We're going to fulfill this outcome, this good ending that God has planned for us right now. I hope that you guys can see the house of cards that's been stacked right now and how quickly and easily it can fall, because at any moment, in a blink of an eye, in the swipe of a pen, in an instant, this can change and we shall be free. So thank you guys so much. God bless and have a great day. Okay. Thank you.